The Honourable Member for Nipissing-Temiskaming.
Thank you, Mr. Speaker. I'm pleased to have the opportunity today to speak on Bill S-7, the Zero Tolerance for Barbaric Cultural Practices Act. This bill strengthens Canada's commitment to preventing and responding to early and forced marriage and other barbaric cultural practices, both at home and abroad. Mr. Speaker, as a member of the Standing Committee on Citizenship and Immigration, I am pleased to see that our government is taking action and protecting young women and girls. Last year, the committee undertook a study strengthening the protection of women in our immigration system, and I am pleased to see that some of the recommendations and comments from the witnesses were taken into account when creating this bill. I'm proud to say that Canada has made ending child, early, and forced marriages a priority. In October 2013, Canada announced $5 million in new money to address the causes and consequences of early and forced marriages around the world. These funds were used for programs in Afghanistan, Ethiopia, Ghana, Somalia, and Zimbabwe. More recently, in July 2014, the Minister of Foreign Affairs announced that Canada is contributing $20 million over 2 years to UNICEF toward ending child, early, and forced marriage. The UNICEF project aims to accelerate the movement to end child marriage in Bangladesh, Burkina Faso, Ethiopia, Ghana, Yemen, and Zambia by supporting efforts in these countries to strengthen both programming and political support to end the practice. Canada has also played an important role in bringing world attention and action to this issue of child, early, and forced marriage through actions such as spearheading the initiative to establish the International Day of the Girl Child and co-leading with Zambia a United General Assembly resolution on child, early, and forced marriage. These barbaric practices predominantly affect women and girls and impair their rights and their ability to fully participate in society. Equality of men and women under the law is a fundamental Canadian value that shapes Canadian policy and actions both in the international and domestic areas. Free and healthy societies require the full participation of women. Sadly, in many countries around the world, millions of women and girls continue to be prevented from full participation by violence, including through inhumane practices of early and forced marriage. It is both the reality and the strength of our country that Canadians of very different origins live and work side by side together. These new Canadians work hard to learn our languages, our values, and our traditions, and in turn are welcome as equal members of the Canadian family. The languages, cultures, and traditions of new Canadians add to the diversity of Canada, which enriches our lives. At the same time, harmful cultural practices which go against Canadian values and are in violation of Canada's international human rights commitments will not be tolerated in Canada. Our government is aware of the causes of the cases of Canadian children being taken abroad for early forced marriage. Canada is committed to protecting and defending those who are vulnerable to these practices both domestically and internationally. This summer, the Minister of Citizenship and Immigration participated in several consultations on these issues across the country. Participants told the minister that early and forced marriages are still a harsh reality in Canada. Our Conservative government has demonstrated its leadership in this area by introducing this bill and also continuing to work with our international partners and community members to find ways to end such harmful practices which tragically are happening each and every day around the world. Bill S-7 will strengthen Canadian marriage laws by establishing new national minimum age for a marriage of 16 years. Currently, only in Quebec is the minimum age of marriage 16 years. This is because specific federal laws apply only in Quebec, but in other parts of Canada, the common law applies. This bill will now set 16 as a minimum age for marriage across Canada. Some may query why this bill has not raised the minimum age to marry to 18. The approach in this bill seeks to balance the protections for children against flexibility to reflect the choices of mature minors between the ages of 16 and 18 who make a commitment to one another, such as those who have a child together. It also aligns with the approaches taken in other like-minded countries. Bill S-7 also contains measures that would amend the criminal code to criminalize certain conduct related to underage and forced marriage ceremonies by knowingly officiating or knowingly and actively participating at an underage or forced marriage. For example, these offenses may apply to individuals who engage in conduct specifically intended to facilitate the marriage ceremony, such as acting as a legal witness, knowing that one of the parties is under the age of 16 or marrying against their will. These proposed new offenses would be punishable by a maximum of 5 years imprisonment. Proposed amendments will also criminalize removing a minor from Canada for forced or underage marriage. This is done by adding the new offenses in relation to underage and forced marriage in the existing offense of removing a child from Canada to commit female genital mutation or sexual offenses. This offense is punishable by a maximum of 5 years imprisonment, and Bill S-7 maintains this penalty. Countries such as Australia and Norway have similar criminal measures which Canada has looked to in the development of this bill. Other proposed amendments in the bill are prevention measures that would provide courts with the authority to issue peace bonds and conditions on an individual where there are reasonable grounds to believe that a forced marriage or underage marriage will otherwise occur. As part of the conditions that would be available, a court would order a defendant to avoid making any plans or arrangements for a marriage, whether inside or outside Canada, to surrender travel documents or participate in a family violence counseling program. The creation of specific forced or underage marriage peace bonds to prevent someone from being taken abroad for the purpose of early or forced marriage are similar to forced marriage civil protection orders in the United Kingdom. In addition, Bill S-7 will amend the criminal code to ensure the defense of provocation won't apply in so-called honor killings and many spousal homicides. Currently, any conduct by the victim, including insults or other forms of offensive behavior, are lawful, can potentially qualify as provocation if it is found to sufficient to cause an ordinary person to lose self-control. The accused was not expecting it, and the killing was sudden. The proposed amendment would limit the defense of provocation so that a lawful conduct by the victim might be perceived by the accused as an insult or offend that person in their sense of family honor or reputation. Cannot excuse murder only conducted by the victim that amounts to a relatively serious criminal offense, i.e. an offense under the criminal code punishable by at least 5 years imprisonment, could be argued to be provocation for the purpose of defense. The provocation defense has either been abolished or restricted in almost every common law jurisdiction like Canada, such as most Australian states, New Zealand, and the United Kingdom. Finally, to better prevent polygamy from occurring on Canadian soil, Bill S-7 will create a new ground of inadmissibility for practicing polygamy in the Immigration and Refugee Protection Act. A criminal conviction or finding of misrepresentation is currently required before polygamists can be found inadmissible. This bill would make amendments to the IRPA so that a polygamous permanent resident or foreign national who is or will be physically present in Canada with any of their spouses would be considered to be practicing polygamy in Canada. The permanent resident or foreign national could be found inadmissible on that basis alone without requiring evidence that the person misrepresented their situation or has a criminal conviction. I have discussed some of the very important aspects of this bill, which sends a strong message that Canada condemns barbaric cultural practices, not only domestically but internationally as well. Canada has and will continue to be seen as an independent leader on these important international rights. Mr. Speaker, while the opposition refused to even call these practices barbaric, it is clear that our government is actually taking action to prevent these barbaric practices from occurring on Canadian soil. I hope that all honorable members of this House will support this important piece of legislation that will protect victims, predominantly women and girls, from such intolerable and inhumane practices. Thank you, Mr. Speaker.